Ayubowan, very good morning and a pleasant evening at the same time to all of you who join us from all over the world. This webinar is a successful story in many ways. First, participants join us at the same time from all four corners of the world, from different time zones to discuss about a global challenge. Secondly, no travel cost, which means no environmental pollution cost. We are blessed to connect with world-class legal scholars on environmental law on the same platform. Finally, global environmental issues are universal. Therefore, I strongly believe the solutions should also be universal and also collective. The Center for Environmental Law and Policy, the CELP, proudly presents this international webinar on the UN climate change regime post-Glasgow. Joining here with us today are the following legal luminaries. A leading climate change legal scholar, Regents Professor of Arizona State University, Professor Daniel Bodansky. A leading environmental law expert, Professor in Public and International Law, Professor Ellen Hay of Erasmus University of Rotterdam. A leading intellectual property right expert in Sri Lanka, a Max Planck scholar, the Dean of the Faculty of Law, Dr. Sampath Kunchiheva. Now, I cordially invite Dr. Sampath Kunchiheva to begin with his opening remarks in this beautiful morning in Colombo. Over to you, Dr. Sampath.
Thank you, Dr. Kokila. Good morning, everybody. I'm truly delighted to be invited to speak a few words at this international webinar on climate change, which is a very timely initiative and long-felt need in the environmental law plane. At the very outset, let me warmly welcome Professor Daniel Bodansky, Professor in O'Connor College of Law, Arizona State University, one of the leading scholars in the environmental law and policy, and also Madam Professor Ellen Hay from the Erasmus School of Law, Erasmus University in Rotterdam, Netherlands, and other participants locally and internationally. Would like to convey warm welcome to you all to this international webinar. Of course, I would say first ever international webinar on climate change. And from you, Dr. Corner Singh, I heard that we are also talking about way forward from Glasgow agenda, and which is very rewarding discussion, and we need to take that forward. And also would like to mention at this very precious occasion that on 5th January 2022 this year, a few weeks before, the University of Colombo launched prestigious Center for Environmental Law and Policy with the patronage of leading legal luminaries and policymakers of this country. And that was a red letter day in the law faculty history. Also, the dedication of the Faculty of Law towards promoting environmental protection and sustainability has a long history, and we are the only faculty which is offering both undergraduate and postgraduate levels the subject of environmental law and research. And we have also I would state at this juncture that with the able leadership of Dr. Corner Singh, the law faculty has initiated a very innovative program called Law Goes Green, which has reached all over the country, and it is, of course, it is a proud product of the Faculty of Law. And Faculty of Law has also collaborated with the other leading think tanks and policymaking institutions with regard to the launching and compiling of drafting of the South Asian Environmental Law Review, which was launched in the month of December. So we have made a lot of success in this endeavor, and Center for Environmental Law and Policy, CELP, is now got on the ground, and it has a long way to go, but it is successful, and I'm so grateful for this opportunity to speak. And I would like to end my short welcome speech with a positive note that the CELP, Center for Environmental Law and Policy, will go from strength to strength with the able leadership of its co-founder, co-director, Dr. Cornersingh, and I congratulate you on this great achievement. And sir, madam, would like to listen to you, and of course you will contribute to the discourse while expanding the horizons of environmental law jurisprudence at the global level, not only limited to Sri Lanka. And of course, we are fortunate. The pandemic has become a blessing to us that we get world-class scholars on the same platform without polluting the environment or anything, without any impact on the nature. With these few words, thank you very much for the invitation. Over to you, Dr. Kokila.
Thank you very much, Dr. Kuncheva, for those inspiring words as the Dean of the Faculty. So without any delay, because it's very late night for Professor Bodansky, may I now gratefully and respectfully invite Professor Bodansky to commence his speech.
Thank you very much. And I want to thank Dean Kuncheva and Kokila and the whole team there at the Center for Environmental Law and Policy for inviting me to speak tonight. I guess this morning your time, but this evening my time. And I'm sorry I can't be there in person, but I do appreciate that I am saving my carbon budget some by not flying all the way out there. So my topic is the UN climate change regime post-Glasgow, but I think to understand the climate change regime going forward, we need to understand where it's come from and what it consists of. So my talk today is going to have three parts. The first part is a brief history of the climate change regime. How did we get to where we are today? The second part is going to be focusing on what I call the Paris paradigm, the key features of the Paris Agreement. And then the last part is going to be looking at Glasgow, what was accomplished, looking forward from Glasgow. So looking back, the road to Glasgow, I like to describe the development of the climate change regime as a play in 4 acts. The first act was the development of the Framework Convention on Climate Change, which establishes the basic structure of the regime. Then you have the Kyoto Protocol in 1997, the Copenhagen Accord in 2009, and then the Paris Agreement in 2015. And I think to understand the development of the regime, it's important to focus on 3 recurring themes in the climate change regime from the very beginning. The first question is the question of legal bindingness. To what extent should the regime be legally binding or not? To what extent should it have the force of international law? The second theme or issue is to what degree should the regime prescribe what countries must do from the top down? And to what extent should it allow countries to develop on their own from the bottom up what their climate policies are going to be? And then the third issue is how should the regime address differences between developed and developing countries? Now, in trying to address those 3 issues, I think we need to keep in mind what the ultimate goal of the climate change regime is, which is to prevent dangerous anthropogenic climate change. And that requires reducing emissions very significantly. And what I call here the effectiveness trilemma is that the problem of reducing emissions is really, I think, a function of 3 factors. How ambitious is the regime? How stringent are the provisions? What kind of emission reductions does it call for? Secondly, how many countries and which countries participate in the regime? If you have a great regime in terms of emission reductions, but key countries aren't participating, then the regime's not going to be effective. And then the third factor is compliance. You can have a great regime in terms of its requirements, a lot of countries participating, but if countries aren't complying, again, then you don't have environmental effectiveness. And the problem, of course, is that these three variables are interdependent. If we raise ambition, we can lower participation or we can make compliance more difficult. But then if we push for maximum participation, we can that might require lowering ambition. So these three variables are interdependent. And the problem is trying to find the right combination of them that's going to maximize the output of the regime, which is getting countries to reduce their emissions of greenhouse gases. So the Kyoto Protocol, where I'll start, takes one approach to addressing these three issues. It's a very legalistic regime, legally binding emissions targets that are backed up by a binding compliance mechanism. But it's top down. It sets the targets for each country internationally. The targets were the product of international negotiations, rather than determined by each country from the bottom up. In order to get that, it had to be very strictly differentiated because developing countries were unwilling to adopt a legally binding emissions targets that were so the regime differentiates between so-called Annex 1 and non-Annex 1 countries, essentially developed and developing countries where developed countries had targets and developing countries didn't. So the Kyoto Protocol was strong, I think, in ambition. It's strong in compliance, at least in theory. It had a very strong compliance regime by international law standards, at least, but very weak on participation. It needed to differentiate, as I said, between developed and developing countries to get developing countries to join. And it was weak in emissions coverage as a result, and also because, of course, the US didn't join. So then the Copenhagen Accord went to the opposite extreme from the Kyoto Protocol. It's a not binding agreement. It was a political agreement rather than legal. Its emission targets were pledges rather than legal obligations. These pledges were developed from the bottom up. Each country got to nationally determine its own pledge. And as a result, it didn't need to be nearly as strongly differentiated. It was able to get participation by many countries without differentiation. So if we think about Copenhagen, it's weak on ambition because it's bottom up. It's relatively weak on compliance. It's not legally binding. It had very few international rules. On the other hand, the plus, of course, was that it had very, very high participation. Most countries joined the Copenhagen-Cancun regime. So the question for Paris has always been, when Paris was being negotiated, was to what degree would they follow the Kyoto model of a top-down legally binding, but then differentiated type of agreement, or to what extent would they adopt the Copenhagen approach of a bottom-up, not legally binding and more uniform agreement across countries? And the solution is sometimes referred to as the Goldilocks solution. It's a hybrid approach between the two, where it's a treaty. So that's like the Kyoto Protocol and like Copenhagen, but not all of the provisions are legally binding. Its NDCs, its nationally determined contributions, are developed from the bottom up, but then it has a lot of procedural rules that were multilaterally negotiated. So it's a combination of the two. And its approach to differentiation, it has some differentiation, but it's much more targeted or nuanced than the Kyoto Protocol was. So let me, in my second part, briefly describe what I call the Paris paradigm, the approach to addressing climate change reflected in the Paris Agreement. And I think it has four main components. The first is nationally determined contributions. The second is transparency to promote ambition and accountability. The third is an ambition cycle to promote stronger action over time. And the fourth is a more nuanced approach to differentiation. And let me go through these four elements of the Paris paradigm in a little bit more detailed. So the first element is the nationally determined contributions. As I said, they're bottom up. Each country can nationally determine the type of contribution it's going to make, the scope of its contributions, which gases and economic sectors are covered. There are some soft expectations about the substance of nationally determined contributions. For example, that developed countries should take the lead by having economy-wide targets, while developing countries are only encouraged to move in that direction. There is a soft expectation of progression over time, where countries are going to progressively ratchet up the ambition of their NDCs. But the NDCs themselves are not legally binding. There's no obligation to achieve a country's NDCs. The actual obligations in the Paris Agreement are of a procedural nature to put forward an NDC, to maintain the NDC, to take domestic actions to implement the NDCs, and to communicate successive NDCs every 5 years. So the obligations are of a procedural nature rather than of a substantive nature. The second element of the Paris paradigm is an emphasis on transparency. So normally we look to legal bindingness to promote ambition, promote accountability and compliance. The Paris Agreement, as I said, with the NDCs, they're not legally binding. So rather than rely on legal bindingness to have countries achieve their NDCs, the Paris paradigm relies on transparency. So it has a variety of legally binding procedural obligations relating to transparency. Countries have to provide information up front, so we actually can, everyone can understand what their NDC means. They have to account for their NDCs. They have to report biennially on their emissions, and on their progress in implementing their NDC. So the idea here is that if countries have to be clear about what they're planning to do, what they're pledging to do, and whether they've actually achieved what they're doing, that's going to be a motivator for them to put forward an ambitious NDC to begin with, and then to implement that NDC later on. And then in addition to these transparency provisions about reporting by countries, there are also a variety of international review mechanisms, a technical expert process, a peer review process, and then an implementation and compliance mechanism. The third element of the Paris paradigm is the ambition cycle. So countries' pledges going into Paris, everyone agreed, were insufficient to meet the Paris temperature goals. That's in fact noted in the decision that adopted the Paris Agreement, the gap between what countries were pledging to do going into Paris and what was needed to be done in order to limit temperature increase to 2 or 1.5 degrees. So the Paris paradigm tries to address that through the so-called ambition cycle, where countries put forward their NDCs, that report on their progress in achieving their NDCs, that's reviewed through these various mechanisms I mentioned. And then every 5 years, there's a global stock take to assess how the world is doing in achieving the Paris Agreement goals. And then countries are supposed to then go back and put forward a new NDC, taking into account the results of the global stock take. And so through this 5-year cycle, the idea is that countries will progressively ratchet up the level of ambition of their NDCs and thereby close the gap between what they're pledging to do and what needs to be done to keep temperature to increase to safe levels. And this 5-year cycle is really, I think, relying on the idea that every 5 years there'll be a huge amount of attention internationally on what countries are going to do. There's going to be essentially political moments every 5 years where the international community is focusing on climate change and essentially putting some kind of peer pressure on countries to put their best foot forward and come forward with a stronger NDC. So this is the ratchet mechanism showing the idea is the progressively stronger ambition of countries' NDCs over time. And then the final element of the Paris paradigm is a nuanced approach to differentiation. With mitigation, there's a self-differentiation, so each country gets to define their own NDC and differentiate what they're going to do from other countries. There's some soft distinctions between developed and developing countries and normative expectations. For example, as I said, developed countries should adopt economy-wide targets. There's a hortatory norm in favor of that, whereas developing countries are only encouraged to do so. But the key, though, is that in the mitigation section, the procedural commitments, which are key to that whole area, they apply equally to all parties. So there's not differentiation in the core commitments, legal commitments of countries. Everyone has to put forward an NDC every 5 years. Everyone has to report on their progress in achieving their NDCs and then go through these various review mechanisms. So, so on the transparency, that means that there are common modalities, procedures, and guidelines for all countries. There's a unified transparency system. There is flexibility for developing countries, but it's not necessarily for all developing countries. It's for developing countries that need it in light of their capacity. So developing countries that want to have flexibility need to put forward justifications for why they are in fact require flexibility given their lack of capacity. The area where there still is a differentiation, a strong differentiation between developed and developing countries is with respect to finance, where developing countries have a legal obligation to provide finance, whereas other parties are only encouraged to provide support. So let me just mention, before I finish on Paris, some other key features of the Paris Agreement. There's the temperature goals, which I'll come back to in a moment, to hold temperature increase to well below 2 degrees centigrade, and to pursue efforts to limit increase to 1.5 degrees. There's also an emissions goal in the Paris Agreement. There's an aim for global peaking of emissions as soon as possible, and for zero net emissions in the second half of the 21st century of this century. There's a goal of fostering climate resilience and adaptation, and a goal of making financial flows consistent with the other goals of the Paris Agreement. There are also two market-based approaches in the Paris Agreement: an emissions trading system and a project-based mechanism in Article 6. There are measures to encourage greater adaptation efforts. There's the Warsaw International Mechanism on Loss and Damage, which is dealing with the issue of unavoidable damages due to climate change. And then finally, there's the finance mobilization goal of $100 billion per year, which was put forward in Copenhagen first, but it was extended through 2025 in the decision of the parties that adopted the Paris Agreement. So these are the key features of Paris: the NDCs, the bottom-up approach to defining mitigation contributions, the reliance on transparency, the nuanced approach to differentiation, and then finally the ratchet mechanism, or the ambition mechanism, to ratchet up ambition over time, with the goal of achieving the limitation of temperature increase to well below 2 degrees, and ideally to 1.5 degrees. So if we think about then Paris in terms of what I call the effectiveness trilemma, its ambition is low initially, but then the ambition cycle is intended to ratchet up ambition over time. Very good on participation, very high participation by countries, and then on compliance, reliance on transparency, not legal bindingness, to get countries to actually do what they say they're going to do. And over on the right is just a graphic showing the gap between the NDCs put forward in Paris and what's needed to keep temperature increase, the emission trajectories necessary to keep temperature increase to well below 2 degrees and to 1.5 degrees. So was Paris an historic deal, as many people said in 2015 when it was adopted, or was it essentially hot air where countries are continuing just to talk about the climate change issue as the sea level is rising around them, and they're really agreeing to do nothing? And I think to think about that, it's useful to think about sort of what can international law do? What is a reasonable expectation of what Paris might do? And how does Paris look compared to those, what might be possible? So I like to think about international law as potentially having three different kinds of models for how it might work. One is a prescriptive model where international law tells states what to do. The second is a contractual model where international law essentially memorializes and enforces what states agree to do, what's in their reciprocal best interest. And then the third is a facilitative or catalytic model where international law catalyzes, encourages, reinforces actions by countries. Now, the prescriptive model is, I think, how a lot of people think about law, how law operates in many contexts in the domestic arena, how law in some cases, fairly unusual in international law, how it operates internationally. But I think the prescriptive model has, I think, limited application to the climate change issue, because there's first the issue of who prescribes the rules. There's no international legislature to do so. There's really nobody who can say what is the rule. Well, I'll come back to that in just a second. But there's a lack of ability to prescribe the rules. But I think the bigger problem is very limited ability to enforce the rules. I think about international law as being a very, very small hammer there, trying to drive a very, very big nail, which is basically fundamentally state behavior. And the small hammer of international law in terms of enforcement, in this case, I think is not up to the job of getting countries to change that very big nail of their entire economic structures. I think the one place where the prescriptive model is now being attempted to be used is to try to bring litigation to force countries to change, because courts can, in fact, lay down rules and then try. There's still a question as to whether those rules will be complied with, with whether the decisions will be complied with. But I think the whole movement towards climate change litigation, the proposals to bring advisory opinions, requests for advisory opinions in the International Court of Justice and the International Tribunal for the Law of the Sea, they all really are presuppose a prescriptive model of law where the courts are going to be able to set forth what the rules are with respect to climate change mitigation, with respect to emission reductions, or with respect to liability and compensation for loss and damage. The courts will be able to prescribe the rule, and then the question will be whether there's going to be compliance with those rules. The second model is the contractual model, which I think is the one that's used more commonly in international law, where international law is based on reciprocity. States accept commitments in exchange for other commitments. Everyone's better off from the deal. It's a win-win. It's getting to yes. For really the precondition is for negotiations to succeed, there has to be some kind of contract zone, a set of agreements that's going to leave all participants better off and are going to be acceptable domestically. And the role then of international law is to basically enhance the contractual environment, make it easier for countries to reach agreement by providing a greater credibility for commitments, providing transparency so countries can see whether other countries are complying and so forth. The contractual model, I think, is what underlay the Kyoto Protocol, that you're going to be able to internationally negotiate emission reduction targets. It's legally binding to try to provide credibility to those commitments. It has a strong compliance mechanism. But I think the Kyoto Protocol illustrates that the contractual model doesn't seem to work very well with respect to climate change, even though one would think it would, because there's huge net gains, global gains to be had if one can reach an agreement by which countries would limit their emissions. But I think the reason it doesn't work, the contractual model has had limited success on the climate change issue, is that climate change, I think, is an issue driven largely by domestic politics rather than international politics. Climate change implicates virtually all sectors of a country's economy. And so there's huge amounts of domestic politics about changing one's energy system, changing one's transportation system, changing one's agricultural systems. So as it's turned out, most countries, in fact, are not willing to do more in exchange for agreement by others. There's not that kind of idea of reciprocity. There is reciprocity, of course, but there's not a willingness to limit one's own freedom of action, one's own sovereignty in exchange for promises by others to reduce emissions. So that leaves us with the catalytic model, which I think is really the model that underlies the Paris Agreement, where states have some willingness to take action on their own. There's lots of domestic problems with them going forward. So the role of the international regime is to encourage a learning process, so countries change their perceptions of self-interest, focus international attention that helps empower domestic constituencies and give domestic constituencies more leverage domestically to try to get stronger policies adopted, that promotes transparency to focus soft pressure on countries and to provide assistance to countries so that they have the capacity to do more to address the climate change issue. So I think that is the model that underlies the Paris Agreement. I think it's the only model that's likely to be, I think the history of the climate change regime illustrates it's the only model that might have some prospect of success. I think there are two big questions relating to the Paris Agreement. One, that this was coming out of Paris itself. One was whether the Paris paradigm was going to be stable, whether it really represented the meeting of the minds. And my cartoon here says everybody's thought bubble is they're disagreeing with it, but they all say I. And was that what happened in Paris, that everybody really disagreed, but they all said I? And I think there was significant question coming out of Paris, whether Paris just papered over differences or whether it really did achieve some kind of new meeting of the minds. But I think the Katowice meeting, where countries adopted the Paris rulebook, illustrates that there, in fact, is some durability to the Paris paradigm, that there is a significant buy-in to it, because the Paris rulebook, I think, kept in place the key elements of the Paris paradigm that I went through earlier. So the other question, and of course the question going forward, is will the Paris paradigm work to raise ambition? Will, in fact, this idea that the Paris Agreement can help catalyze stronger action by countries over time really play out in practice? And that's why the Glasgow meeting was so significant. And this brings me to the last part of my talk. because it was really the first test of the Paris paradigm, whether the Paris paradigm was really working to be able to raise ambition. Now, before I get to Glasgow itself, I just want to make two preliminary points about COPs in general, Conference of the Parties in Glasgow. So the first is that I think now COPs have taken on two different dimensions. So I call it a tale of two COPs. There's the COPs as a meeting of the parties. So this is what traditionally COPs have been, and what COPs mostly are in other multilateral environmental regimes. They're a meeting of the parties where the parties to the agreement take care of business relating to the treaty. So COP3, for example, adopted the Kyoto Protocol, COP21 adopted Paris, COP24 adopted the Paris Rulebook. These are meetings of the parties doing the work of parties to the agreement. But the COPs in the climate context have also taken on a second element, in some ways a more important element, where they're major events, they're focal points. They're focal points for non-state actors, they're media events, they're trade fairs, they're forums for NGOs and academics. So they've taken on this much broader dimension. And if we think about the development of the climate change regime, really, when I've been going to COP since COP1. In fact, I've been going to climate meetings before there were COPs. And I think there's really been an evolution of the COPs from the main focus being a meeting of the parties to the main focus being COPs as mega events. It used to be there were only a few mega COPs, as we call them, but now every COP is essentially a mega COP. And it's not just a state-centric meeting anymore, it's a multi-actor meeting where other kinds of actors, non-state actors, subnational governments, cities, provinces, business, environmental actors, agricultural community, indigenous groups, and so forth are all playing significant roles at the COPs. And the COPs are now no longer, I think, just purely climate-centric, because climate raises so many other issues, issues about intellectual property, about trade, about human rights, about indigenous rights. And so all of these are now playing into the COPs as well, as COPs have developed from being a simple meeting of the parties about a climate agreement to being a mega event about all of the different implications of climate change. So if we think about COP26 then, Glasgow, there was the official agenda. So that's the COP as a meeting of the parties. So the official agenda was to complete the loose ends of the Paris Rulebook. There were a few things that hadn't been agreed to in Katowice. Most importantly, the rules for the two market mechanisms in Article 6 and common reporting tables under the transparency framework. And having common reporting tables makes it much easier to actually easily know what countries are saying they're doing. It makes it easier to compare what countries are doing. So having some common reporting formats or tables, I think, was key. And then common timeframes for NDCs, again, so that these political moments can be created and you can compare what countries are doing. So these are important elements, these elements of the official agenda. In addition, launching a process to develop a new finance target, spelling out what the global goal and adaptation means, operationalizing the system to address loss and damage, the Santiago network. These were all important elements, but I think in some ways they were overshadowed by the political agenda of COP26, because I think what made COP26 such a key conference of the parties was, as I said, it's the first real test of whether the Paris paradigm seems to be working, whether Paris is on track or not. So the political agenda included raising mitigation ambition, and that included both the nationally determined contributions and the so-called long-term strategies to reduce emissions. There was a huge political issue because the $100 billion pledge to mobilize climate finance had not been met this as of last year. And so there was very large dissatisfaction on the part of developing countries, understandably, that developed countries hadn't actually come through with what they pledged to do back in Copenhagen and again in Paris. And then the UK had a whole series of goals as part of their political agenda to have a series of side deals dealing with a whole series of sectors and gases. So coal, cars, finance, trees, methane, nature-based solutions. So that was the political agenda. The other sort of preliminary point I want to make is that about the COP and about Glasgow is the COPs are, I think, are no longer just discrete events, they're processes. So the COP is not just Glasgow, it's the whole year leading up to Glasgow. And so if we think about the year leading up to Glasgow, pre-Glasgow, there were significant new announcements about NDCs, not made in Glasgow, but made in the run-up to Glasgow. And so this is showing some of the key NDCs that were revised and ratcheted up in the run-up to the Glasgow conference. And you can see it still leaves a significant gap between what countries have now pledged to do under these new NDCs and what needs to be done to get to 1.5 degree, but still a closing of the gap from the old NDCs in September 2020 to the ones that were put forward in the first half of 2021 in this year leading up to Glasgow. All right, so finally getting to Glasgow itself. So I think there were 5 main outcomes or 5 things I want to highlight for Glasgow in terms of their outcomes. So first is more ambitious NDCs. Second, the net zero pledges. The third were a series of side deals brokered in many cases by the United Kingdom, which was the presidency of the COP, the Paris rulebook, and then finally the Glasgow Climate Pact. So let me briefly go through these 5. So the first is more ambitious NDCs. So a bunch of countries, as I said, submitted NDCs before the COP, at the COP. China made an announcement. These, according to Climate Action Tracker, reduced the gap in emissions by about 15 to 17%. But as the COP decision at the end of Glasgow noted, that still leaves a significant gap between what these new pledges do and 1.5. So progress, but still a long way to go before the Paris goals are likely to be achieved. In addition to these NDCs that were put forward, a series of net zero pledges. So Paris Agreement calls on countries to get to net zero in the second half of the century, but this has now been converted into more like a target to reach net zero by mid-century, by 2050. So a number of countries pre-COP put forward net zero pledges, including the UAE and Saudi Arabia. At the COP, more countries put forward new net zero pledges. In some cases, 2050. In the case of India, 2070 is their target date to achieve net zero. So now 81 countries representing 3/4 of global emissions have put forward pledges to get to net zero around mid-century or in a decade or two after mid-century. The third element is the UK's or the side deals that were brokered in many cases by the UK, but in many cases also with a lot of other countries involved as well. I think the one that's the most important in my mind, at least, is the global Methane Pledge to cut methane emissions by 30% by 2030. There's also were side deals on coal and clean power transition, on zero emission cars, on finance, 450 financial institutions from 45 countries that manage $130 trillion in private capital, pledged to work to get to net zero emissions by 2050. There was also a leaders declaration on forests, so a series of these side deals. The Paris rulebook negotiations were successfully concluded, so there were rules adopted now for Article 6 mechanisms. I think regarded by most observers as relatively strong, at least in terms of the spectrum of options that we had going into Glasgow. There was also agreement on the transparency tables, which I think are also extremely important, an agreement to essentially have 5-year cycles for putting forward your NDCs. And the NDC, so you'd put forward an NDC for 2035 and 2025, for 2040 and 2030, and so forth and so on. And then a 2-year work program to enhance understanding and implementation of the global goal on adaptation. So this was one of the main asks by Africa, which has been pushing the idea of developing a global goal on adaptation to go along with the goals on temperature and on emissions that are specified in the Paris Agreement. So there's now a 2-year work program to try to develop that. And then finally, we have the Glasgow Climate Pact. That was the umbrella decision that was adopted at the very end of the agreement. It's one of these things where I think it's reported as something sort of that came out of thin air, but I think the Glasgow Climate Pact was something that was being negotiated quietly throughout the year leading up to Glasgow. So most of the focus in the media in the Glasgow Climate Pact was that instead of calling for a phase out of coal power, it instead calls for a phase down of coal power, and it's only of unabated coal power. So phase down rather than phase out. In my mind, what's more important here is that for the first time, a climate decision, a climate conference decision actually mentions coal power and specifies coal power and singles it out as something for special attention, because up until then, in the 30 years of the climate change regime, there have been no COP decisions specifically focusing on coal. I think probably the most important element of the Glasgow Climate Pact is the idea that by the end of 2022, countries are supposed to revisit and strengthen their 2030 NDCs in order to align them with the Paris temperature goal. So normally it's a 5-year cycle, as I mentioned. So the idea was every 5 years, countries would go back and sort of take stock and decide what they're going to do next. So if that was going to be the case, then we'd have to wait until 2026 until we got new NDCs. I think that was seen as completely inadequate given the urgency of the climate challenge. So instead, the COP, by consensus, agreed to this language requesting countries to revisit and strengthen NDCs this year, by the end of this year. So that's going to put a lot of attention again on what countries are doing, what they put forward, and again, hopefully provide motivation for countries to put forward stronger NDCs by the end of the year. There's also an invitation to consider actions to reduce non-CO2 gases. They note with regret that the 100 billion wasn't met. And there's, I think, now increased urgency to try to close that gap in the next couple of years. I think because of the developed countries were embarrassed by not meeting the goal, they agreed to double adaptation finance in the Glasgow Climate Pact, and then established a dialogue to discuss funding arrangements for loss and damage, which again is a significant move forward on the loss and damage issue, because finance has never been really part of loss and damage up until now. And finance is something developing countries are very interested in discussing with respect to loss and damage, because they're the ones who are suffering by far the biggest levels of damage. There was also a US-China joint declaration at the end, which was a bit of a surprise, but I think provided quite a good signal towards the end of the meeting that helped get the Glasgow Climate Pact agreed to, that the US and China, despite all of their political differences on many other issues, continue to work together closely on the climate change issue. So is Glasgow half full or half empty, as people are now saying? And there's big evaluations, different answers to that. So Greta Thunberg, I think, would probably say it's more blah, blah, blah. Alok Sharma, who was chairing, was expressing regret. John Kerry's articulating a quite positive outlook on the outcome. So I have here my report card. It's just my attempt to try to sort of summarize how the Paris Agreement's doing, and now that we've had Glasgow has come and gone. So I would give the Paris Agreement extremely high marks in terms of shaping normative expectations. When Paris was adopted, the temperature goal was 2 degrees, well below 2 degrees. I think now there's really pretty strong agreement internationally that the actual goal of the climate regime should be to limit temperature increase to 1.5 degrees goal, but 1.5 degrees maximum. If you had asked me 6 years ago whether 1.5 would sort of now dominate, I would have been skeptical, but there's been really, I think, a huge degree of socialization of the notion that countries, that the goal is to get to limit temperature increase to no more than 1.5 degrees, and on net zero, not just to get to net zero by the end of the century, but get to net zero by mid-century. So in terms of shaping normative expectations, I would give the Paris Agreement quite high marks. I'd also give it, I'm sorry, here, I'd also give it pretty high marks on creating political moments. The Glasgow conference, I think, really was a political moment. It got a huge amount of attention. It was the first time, at least in the US, that a climate COP was the top of the news every night of the COP on the major news programs, which certainly had never been the case before. So I think in terms of creating a political moment and getting the world's attention focused on climate change, again, I would give the Paris Agreement in Glasgow high marks. And we can see that with participation, even during COVID, even during all the restrictions participation at the COP was at record highs. In terms of finishing the Paris rulebook, pretty good marks. They actually did finish the negotiation of the Paris rulebook. I think, at least my view is that the Article 6 rules relating to emissions trading and the project-based mechanism are on the stronger end of the spectrum. They did get the common reporting frame table. So in terms of outputs from the Glasgow meeting, pretty good. Weaker in terms of ratcheting up NDCs and net zero targets, but I think while they're still way short of where we need to be, I think it's also good to take note that there's progress that's been made. Pre-Paris, people thought we were on track to 3.7 degrees temperature increase. Going into Glasgow, it was more like 2.6 degrees, somewhere between 2.6, 2.9 degrees. Coming out of Glasgow, according to Climate Action Tracker, the pledges and mid-century net zero targets put us on a pathway to 2.1 degrees centigrade. Now, of course, that assumes that the NDCs and net zero targets are going to be achieved. So that's a quite optimistic assumption. But at least in terms of what countries are saying they're going to do, there's been really quite significant progress, even though there's still a long way to go. And then I would give some extra credit here for the Methane Pledge. Methane is a huge contributor to global warming because it's such a strong greenhouse gas. The Methane Pledge, again, we don't know whether it's going to be achieved, but if it's achieved, it will make a significant contribution, and particularly in the short run, because methane has a very short atmospheric lifetime. It's extremely potent greenhouse gas. And so if you can cut emissions of methane quickly, then you get a quite immediate climate response, whereas with carbon dioxide, the response is much slower in terms of the effect of emission reductions in terms of limiting temperature increase. Now, in terms of evaluating the Methane Pledge and the other side deals, with these side deals, at least the International Energy Agency thinks that would put us on, if they're achieved, if all these side deals are achieved, would put us on a pathway to 1.8 degrees. So that's now better than the 2 degree target in Paris and beginning to approach the 1.5 degree target. Other analysts aren't as optimistic. Carbon Resources estimated the effect would be 1.9, Climate Action Tracker more like 2 degrees. So a variety of expert assessments, but all making significant progress in terms of achieving the Paris temperature goals from where we were before. Still not on track to 1.5, still a question as to whether these pledges are credible, and only time will tell as to whether countries are really actually implementing them. I think an important element here is what the relationship of all these side deals are to the actual structure of the Paris Agreement. How do they relate to the NDCs in particular? Is what countries are pledging to do on forests, on coal, or on zero emitting vehicles, on methane, are those part of NDCs already? Are they really additional to what the NDCs contain? Until they're incorporated into the Paris framework, then the various transparency requirements of Paris don't come into play. So I think incorporating those pledges into the Paris framework is important, because I think the Paris transparency framework is a key mechanism to try to hold countries accountable and get them to comply with what they say they're going to do. Because of the lack of really any infrastructure dealing with these side pledges, an infrastructure and transparency like what's in Paris, the UN Secretary General announced the creation of an expert group to assess how to assess implementation of the pledges, because I think there's significant concern as to whether these pledges really are real pledges or whether they're simply greenwashing. Weak marks in terms of providing support. Developed countries, as I said, missed the $100 billion mobilization goal. They fell 20 billion or more short. I wouldn't give that a failing grade. In most countries, I think 80% marks is still a passing grade, but it's still very far from doing what they, developed countries doing what they say they're going to do. So I think I would give the low marks on the providing support element. And then finally, the key question, emissions, I give Paris an incomplete. I don't think it's yet has the failing grade. I think it's too early to say. I think Glasgow, to my mind at least, was encouraging because countries did put forward stronger NDCs. They did put forward net zero mid-century targets. There's increasing socialization of the stronger temperature and emissions goals of 1.5 degrees and mid-century net zero. So I think there are a lot of encouraging signs, but in terms of the actual emissions of countries, we still have yet to see significant progress. There was significant reductions of emissions in 2020 as a result of COVID, but then in 2021, we see a bounce back of emissions to pre-pandemic levels. So on the key question, is Paris going in the right direction or not? Is it going to be successful in, is it going in the right direction? I would say yes. Is it going to be successful and incomplete? We don't know the answer to that yet. So going forward now, I think we now have in place really the elements of the Paris Agreement, all of the different rules that needed to be filled in, or most of them, or many of them at least, have now been completed. So we're now moving into, I think, a new phase of the climate change regime going forward, a phase that's going to be focused a lot on implementation of pledges. So countries, our countries actually achieving their NDCs. Are they going to strengthen their ambition of their NDCs in the next round, hopefully later this year? What countries are actually doing to implement their pledges with respect to climate finance? And then I think an increasing emphasis on adaptation and loss and damage, because the focus of the climate regime up until now has been largely on mitigation. I think although the climate change Paris Agreement addresses adaptation and loss and damage, they're really the key elements of it relate to mitigation. So I think going forward on mitigation, there's an emphasis on implementation of what countries say they're going to do. But then I think now increasing emphasis on adaptation and loss and damage. So the Sharm el-Sheikh work program to define a global goal in adaptation, operationalization of the Santiago network on loss and damage, a dialogue to discuss arrangements for funding and loss and damage. So I think that's going to be increasingly the focus of attention at climate meetings going forward. So thank you for your attention. I know that was covering quite a lot of ground fairly quickly, so I look forward to Ellen's comments and then the questions and discussion afterwards. Thanks.
Thank you very much, Professor Bodansky, for that optimistic note at the end after 30 years since 1992 and passing through Kyoto, Paris, and now Glasgow. So over to you, Professor Ellen Hay, who is a member of the advisory board of the CELP as well, and a well-known leading environmental law scholar from Erasmus University of Rotterdam. Over to you, Professor Hay.
Thank you very much. Sorry, Dr. Konasingham, and thanks, Dan, for Professor Bodansky for a very interesting insight into how the climate change regime has evolved, and especially what Glasgow has brought us. There's a number of things that I find very interesting, and perhaps, if I may, also question. I find this, the change that you emphasize from the role of international law, or the role of the climate change regime as moving towards process, towards transparency, towards stimulating process. A very interesting one, one where I do wonder what it will tell us over time in terms of environmental law more in general. Perhaps the question or comment I have is, what can developing countries expect? We see that the 100 billion fund has again not been met. You predict a bigger focus on adaptation instead of mitigation. Adaptation, something that also very much is very problematic for developing countries for various reasons, because, well, I won't go into the details there, but I'm wondering, so after Glasgow, we have a number of additional agreements, the Methane Pledge, very important. but where do developing countries stand in this process, or what can they expect? And in this more process-oriented approach, I guess I'm also wondering, how will the relationship between developing and developed countries fare? And again, in this more process-oriented approach, maybe my fundamental, or the easy way to ask the question would be, where do we see common but differentiated responsibilities in this context? And of course, the principle has changed, but how should we consider this relationship at this moment in time, particularly in the climate change regime? So I would love to hear your thoughts on that.
Should I go now, or do you want to?
No, yeah, please.
Okay, sure. Okay. Well, thank you, Ellen. It's always a pleasure to see you and hear your comments. So I guess I think common but differentiated has definitely evolved over the course of the regime. I think it came in a way that was quite stark in terms of how it was defined. It was defined in terms of annexes that were simply lists of countries that were actually drawn up the last night of the Framework Convention negotiations at about 2 or 3 a.m. Not a lot of consideration given to which countries should be in which annex or not. And then it became impossible to change the listing afterwards because countries weren't willing to amend the annexes. So it's very rigid. So by the time we get to Paris, for example, some of the richest countries in the world were defined as non-Annex 1 countries in developing. And so there was a very, I think, poor fit between the annexes, the way differentiation was done in the Framework Convention, then again in the Kyoto Protocol, a very poor fit between that structure and sort of the changing realities of the world. So I think the Paris Agreement still includes ideas of differentiation. For example, nobody's expecting NDCs of developing countries to be the same as developed countries. The emissions pathway countries take to get to net zero are going to look quite different for developed and developing countries, and that's baked into the system because of the idea of nationally determined contributions. On finance, there's still relatively strong differentiation. And then on transparency, I think from my mind, there's always been a question as to, why exactly do you need differentiation? What is the rationale? And I think the rationale for differentiation on transparency is capacity. So rather than make it a developing, many developing countries have plenty, can certainly report on their emissions and on what they're doing. So, but many countries can't. And so rather than focus on sort of a categorical approach to differentiation, the Paris Agreement focuses on capacity, and lack of capacity as being the reason countries need flexibility. Not every country can do exactly the same thing given their different capacities. So I think there's still differentiation, but I guess in my mind, I of course come to it as a former developed country negotiator, so perhaps my perspective is influenced by that. But I think in my mind, the Paris Agreement moves the differentiation issue in a positive way. Now, you said, what can developing countries expect out of the Paris Agreement? I mean, I think the countries that are most vulnerable to climate change tend to be in the developing world. And so both because of where climate change impacts are going to be felt, and also in terms of adaptive capacity to be able to deal with the effects of climate change. So the whether the Paris Agreement succeeds or fails in terms of limiting emissions and keeping temperature increase to, as close to 1.5 degrees as we can get, that's going to be a huge benefit for developing countries. It's a huge benefit for the entire world, but to the extent that the countries that are most vulnerable are in Africa or small island states, then they're going to be among the biggest beneficiaries of that. And even though Paris right now is not on track to getting to 1.5, and even though we don't know yet whether countries are going to actually achieve their NDCs, one thing that I think that was important from the IPCC's most recent assessment report is that every bit of change, of limitation of temperature increase, there's a significant benefit in terms of reduction in damages. So, 2.5 is better than 3, 2 is better than 2.5. And so, even if Paris doesn't achieve the 1.5 degrees, I think it'll still provide a significant benefit if it reduces emissions to the world generally, and in particular to developing countries that are particularly vulnerable to the effects of climate change. So I think there's a huge benefit there. Now, climate finance, I think, has been a really problematic issue. And I think that developed countries, largely for domestic political reasons, have a hard time providing more finance. So I think that's a problem going forward. I think that the biggest influence on what happens on climate change is probably not going to be the public governmental financial flows. It's going to be the private capital investments. So I think one thing that Paris gets right is that in Article 2 of the agreement, where it sets the goal for finance, it's not just in terms of public finance, it's in terms of financial flows generally. And so to the extent we're able to change financial flows more generally, I think that's going to actually have a much bigger impact on emissions than the actual $100 billion or not. So, the initiative by Mark Carney on finance by financial institutions to try to make investments that are compatible with net zero targets by mid-century, I think that potentially is very big, is maybe more important ultimately than the $100 billion goal. And so, but I think it's too early to say whether that's going to be successful or make a real difference or not. So I think there's some encouraging things, but I'm certainly never, I think there's a lot of question marks too. So, but I don't really see a good alternative to Paris. I think countries floundered for a decade after Kyoto, not really making any progress. So as compared to an ideal world, Paris certainly falls far short compared to the alternatives. I'm not sure I see a good alternative to it.
Thank you. Sorry. No, I think I agree with you on most points. I'm not sure whether the public-private finance, transfer of technology, provision of funding, the 100 billion fund, I think there are some more serious issues to be considered there in the relationship between developed and developing countries. And well, we'll see where that goes. I had one other issue that I was pondering when you mentioned the three models, the prescriptive, contractual, and the facilitative model. And you mentioned climate change litigation. And I thought, oh, okay, that's the national type litigation. But then I think what you meant was the attempts at the moment to bring cases to international courts and tribunals. And I was thinking, how does the climate change litigation that's currently taking place in very many countries, how does that fit into the model? Might that also be a sort of a new way of implementing climate change measures that are at least some of which are internationally agreed. But is there a new role for courts that's evolving, for national courts? And are they part of the prescriptive part of, if you will, of the climate change regime? It's a question I had, and it made me think, and I thought, and might that be a model for other areas of international environmental law where national courts are taking on much more important role?
So I guess I would say, with respect to national courts, I would put national courts as part of the maybe enlarging the hammer in my picture of driving state behavior. So you have the international norms like the Paris temperature goal that have been prescribed actually now through the agreement. So in terms of the two elements, who prescribes and who enforces and how effectively do they enforce, I said there's a problem on both of those, but actually there has been some international prescription. So the Paris Agreement does define the 1.5 and 2 degree targets, for example. So to the extent those targets can then be enforced domestically by courts like the Dutch Supreme Court, then you have a much bigger hammer, because international law is not much of a hammer, but domestic courts, is a significant way of changing state behavior. So I think national courts can play a significant role potentially in terms of translating the international norms into things that will actually change state behavior. I think the international court cases that are being discussed, the advisory opinion and ICJ and ITLOS, that's really more getting somebody to be able to say what the law is. The goal is to have the ICJ say, countries have a duty to internationally to provide compensation for damages due to climate change, or they have a due diligence obligation to do X to reduce their emissions. And so that's basically putting the courts, I think, in the role of the one that can prescribe a norm. And, the courts can, of course, come forward with advisory opinions, but I think the likelihood that those advisory opinions will significantly affect state behavior, I think, is more limited.
Thank you very much, Dan. I'm going to leave my role for the moment. And as always, a pleasure to discuss issues of international law and issues of environmental law with you. But before I give the floor back to the chair, I want to congratulate CELP on its inauguration. I could unfortunately not be part of that meeting. And I very much look forward to working with you in future. And Dr. Bodansky, congratulations on this achievement. Thank you very much for inviting me today as well. I turn the floor back to you.
And can I maybe just interject and say, let me also add my congratulations to the creation of Center for Environmental Law and Policy. And I also hope to have an opportunity to work with you in the future. So thank you.
Thank you so much. We look forward from Sri Lanka to work with both of you, and also the Center for Environmental Law and Policy was actually originated, the idea was originated when I studied under Professor Ellen Hay in the Netherlands for my master's. So you inspired the whole idea, and throughout this journey, very hard journey, you were with me and supported, and you are a respected member of the advisory board now and continue to support us. Thank you so much. And also Professor Bodansky, I used to study and refer your work when I was a student in the Netherlands, and I always had chat with Professor Hay about legitimacy and all of these things that you have written. So you also truly inspired me towards this journey, perhaps not in a direct way, but indirectly and very meaningfully indeed. So thank you so much. And may I now request everyone to turn on your camera, because we are going to take a picture photograph of this very memorable moment. And thank you very much, Mr. Prashantalal Alvis, President's Council. I can see he's joining with us. And also we have Professor from India, Jawaharlal Nehru University, and Professor Amita Singh. And please turn on your cameras, whoever is okay with that. And I can see many foreign students joining with us, and we invite you for collaboration, student exchange, and anything that for your field work. This is ideal place, Sri Lanka, and you are most welcome to connect with us. So please keep your cameras on for the photograph, and Akalanka, please coordinate. Akalanka, are we done?
Yes, madam, I'm waiting for the others to switch on the cameras. Actually, only
I think we can
allow them some time.
Because Bodansky is very late now, so we
yes.
have. Yes.
So I will take as it is, ma'am.
Yes. Yes. Thank you, Akalanka.
Right, it's done, madam. Thank you.
Thank you so much.
Yeah.
Thank you, Professor Bodansky. If you wish, you may leave now, because I know that it's very late and you have a very busy schedule tomorrow. And my humble thanks and appreciation for joining you with us today, and also look forward to work with you in the future. Thank you so much.
We'll invite our distinguished expert to Sri Lanka.
Yes.
The situation improves. I think it's getting better in Sri Lanka. And our distinguished members are most welcome to Sri Lanka, and we'll have the faculty open for them at any time.
Thank you.
Thank you very much. Thank you.
Yes, sir.
I'm going to sign off now because I teach again tomorrow morning very early.
Okay, so. Sir. Thank you. It's our
thank
pleasure.
You again.
Greatly appreciated.
Okay. Good to see you, Ellen.
Okay.
Bye-bye.
Yes, good to see you, Dan. Bye-bye.
Our final item is now is again a very important contribution that CELP has involved. That is a presentation by the World Youth Climate Change, Youth for Climate Change Justice. So, sorry, the World Youth for Climate Justice. Let me correct it. Now, here with us, Dulki Sitawaka, an executive researcher from the CELP, to do a presentation with her colleague. You may first introduce your colleague, and then you may proceed, Dulki. Over to you.
Thank you so much, ma'am. Am I audible?
Yes.
Okay, thank you. So today I have with me Aditi Shitye. She's a lawyer from Mumbai, and she practiced criminal law and civil law before moving to the UK to pursue her Master of Laws in Global Environmental Law and Governance. And currently she's a research fellow at the United Nations Environment Programme, Ozone Secretariat. She's also a research assistant at the Strathclyde Centre for Environmental Law and Governance. Her collaboration with WATHCING began as a contributing author and a co-editor to the legal report published in July 2021, and she has been actively contributing to the campaign ever since. Welcome, Aditi, and thank you so much for being here despite the time difference. The floor is all yours. I'll be sharing the screen.
Hi, hello everybody, and thank you for having me. Thank you, the Center for Environmental Law, the University of Colombo, for having me and allowing me to speak about the campaign. So just to begin, we are World's Youth for Climate Justice, and we are an NGO that campaigns to tackle climate change and human rights to the International Court of Justice to seek an advisory opinion. What we want is to clarify, what we want the advisory opinion to do is to clarify the obligations of states to protect the rights of current and future generations from adverse effects of climate change. And thus the core themes of this advisory opinion what we believe would be not just climate justice, but intergenerational equity in consonance with human rights. So the whole campaign revolves around the need to provide an understanding for a rights-based approach to address the climate crisis, and also the need to utilize international legal mechanisms to clarify and develop the international environmental law in consonance of humanitarian law. So on this note, we had the opportunity to publish a legal report which elaborates on why and how this advisory opinion from the ICJ is a well-justified avenue to advance this development and complement the UNFCCC negotiation process in the broader sense of climate goals community on national, regional, and international level. So who are we exactly? We are an umbrella organizations, and we partner very closely with the Pacific Island Students Fighting for Climate Change, PIFCC. PIFCC was established when a group of students from University of Vanuatu came together and decided to move the ICJ to seek an advisory opinion, and thus were the original initiators of this campaign. And now they have come together along with WICJ, and we form an umbrella organization, and we hope to partner and network with a lot of other non-state actors to gain momentum in this process, gain global momentum in this process. So why do we do what we do? We believe that human rights and climate change are inherently interconnected. The climate crisis infringes on the ability to exercise the exercise basic human rights, and this was also recognized very recently, just last year before COP, that access to a safe environment is a fundamental human right. So issues like global heating, rising sea levels, desertification, biodiversity decline, all of these are interconnected, and we believe that the advisory opinion would be at least a platform, or at least a beginning from where these issues or international environmental principles, as mentioned by Professor Hay and Bodansky earlier, could be clarified, like the intergenerational equity, common but differentiated responsibility, amongst many others. So this is not the first campaign that seeks an advisory opinion on climate justice and climate rights. This was attempted before by a vulnerable Pacific Island state called Palau, and they were seeking clarification on the obligations of states to cut down greenhouse gas emissions to avoid transboundary harm. However, at that point of time, this was before the Paris Agreement, so at that point of time, Palau's attempts were not successful, and based on this, we are trying to cement our argument or our principles into a human rights-based approach. And the ultimate goal would be that we come together and we do get a clarification about achieving various processes or various ways of achieving the targets or the goals set down in the Paris Agreement. So coming to the next aspect, how do we move the ICJ? It is a monumental task, and we are hoping that eventually we do recognize, and not just eventually, but with a steady pace, we do reach our ultimate goal, that is trying to move the ICJ for an advisory opinion. So for this, what we need is we would need a simple majority by around 193 states or 192 states at the UN General Assembly where this could be tabled. And we need states to agree to this for then moving to the ICJ to seek an advisory opinion. For this, we are trying to partner not only with PISF CC, but also other networks and other organizations like WWF, who have also agreed to collaborate with us, and even the Stop Ecocide movement. So this is something that we are currently working on and trying to achieve. And our ultimate goal is to set momentum in as many countries as possible. So we have regional fronts right now, and the most momentous, or the ones that are really established very well so far, are from the Pacific, from Europe, now from Asia, and we are trying to build momentum from Latin America and Africa as well, so that we do get these votes, and or there is a possibility for countries from all these continents to pressurize their governments through the whole non-state movement, as also mentioned earlier by Professor Bodansky, in terms of how climate movements and climate justice movements are taking place. So this is what we see ourselves doing, and this is what we hope to achieve. So the next aspect, is what can an ICJ advisory opinion do? To be very honest, this really depends on how the question that ultimately is before the ICJ is framed. So the question that right now we have come up with is what are the obligations of states under international law to help mitigate, or to help mitigate the climate crisis by elaborating the principles of intergenerational equity from the adverse effects of climate change. But this is not the most concrete question yet. So also this has to be tabled at the UNGA. So it's a big process, but this is the direction that we hope to take, and we are taking actually. So we also believe that it can be a progressive interpretation of these obligations and make global process towards elaborating, as I mentioned earlier, such principles of an international environmental law, and so on and so forth. So coming to the last section is that how we are supported. We fortunately had a platform where we could present our campaign at COP, and before that also we have had support from, we have constant support from Professor Margarita Vervinke-Singh and Kate Dews and Willie Millsack, Kiefer Jackson, and Matthew Hilton. And apart from this, these are our advisors who advise us on the strategy of the campaign and just how to move forward. Apart from this, the government of Vanuatu just last year also did recognize this campaign and has now agreed, or has now announced that they would be pursuing this advisory opinion. So that is my presentation to about what World's Youth for Climate Justice is, and I would like to answer any questions if there are any, and I'm going to give it back to Dulki to conclude. So thank you so much.
Thank you so much. I guess Professor Ellen Hay also made a point that developing countries are the most affected by the impacts of climate change. So maybe it is time for us to take some action, and maybe if the governments of our countries are not doing something, then maybe it is time for us to take the front seat and maybe and guide our governments that this is what we should do, because climate change is real. We are now seeing the impacts of all the natural disasters that are taking place, and it's not a joke. And I would also say that the developed countries are not as affected as we are, and we are just ignoring this, even though we are the people who are most vulnerable. So we would like to request you to join us. Please help us with this campaign, and please help us with promoting this campaign, so that we can make a better world for the coming generations, and hopefully make the world better for everyone. So thank you so much, Kokila ma'am, for giving me this opportunity, for giving WICJ this opportunity to talk to everyone. That's all from our side.
Thank you, Dulki. If anyone has any comments or questions, I can leave some minutes for them. Yes, then we will move on, and I would like to thank Professor Daniel Bodansky and Professor Ellen Hay and Dr. Sampath Puncheva for their wonderful contribution, and also WICJ for again a fantastic contribution, because being the youth and being a major group in environmental governance and decision making, you play a vital role. So this is a perfect example to show that your active contribution towards achieving something very meaningful towards the fight against the global climate change, global warming. So with that note, I will conclude the webinar, and I may call this a very successful event organized by the CELP. We are going to publish this webinar on our Facebook and also on our YouTube channel, and also on our website. So please join us again for another very important intervention for environmental problems at the global level. And until then, may I take the leave saying Aibowan. Thank you so much.